So Principles of Real Estate, Section 2. Here we go. So this is day 1. All right. Chapter 1, title and ownership. So overall, title just means ownership. So that's really important to know. Just title means ownership. Now, the difference between title and deed is evidence of your ownership. It's the written proof of ownership. So that's really, really important. Now, the term alienation sounds like a cool alien movie, but it really just means to separate yourself from title. So you're selling, transferring, conveying. Oh my goodness. Okay, you're selling, transferring, or conveying title. And you're separating yourself from ownership. And that could be voluntary or it could be involuntary. All right. So legal title is an ownership with the right of possession and use, where there are certain other types of title that you can own that you don't get full right of possession and use. So for example, equitable title. So the best way to determine or to describe equitable title is when we're talking.
Sorry. Where exactly are you? Or is this one of your
page 25 in the workbook?
In the workbook, okay. Thank you.
You're welcome.
Oh, thanks. Yeah, I didn't put the alien and flag. You know, if it's got an alien and a flag image, I didn't do it. Okay, yeah, 25. So page 25. Was the last, this one was on, so I guess this was on page 24. Did we skip pages or something? What happened?
I feel like we did it.
Well, these were the slides they gave me. They said it follows the workbook. So, all right, let's go through the 3 different types.
There was in the math section,
we didn't do the math section, right?
Oh,
yeah.
Well, there's more math sections in the slide, so maybe they moved them around. So we might have to pay attention to that and see.
Okay.
But so we'll go back to that, I'm sure. Okay, so the 3 different types of title. All right, this is important. You guys got to know this. So legal title is just the ownership. Like you have legal title. You have ownership. You have right, to use it, possess it. You live there. You could sell it. You have your full bundle of rights. But equitable title is not full ownership. So let's talk about it. It is a type of ownership, but it is not full ownership. So for equitable title, the best way for me to describe equitable title is like this. Let's just say that you guys are going to sell your house. All right. Now you received an offer. Okay. And when you receive the offer, you agree with it all and you sign it. You have now given the buyer equitable rights. What does that mean? It means that the buyer is going to get legal title, and until that time, they get equitable title. So what exactly does that mean? Well, it means that you're no longer just the owner. So if I'm the seller and I agree and I sign a sales contract saying I'm going to sell this house to somebody, I can't just go in and paint all the walls pink and do whatever the heck I want to do, because I'm not the only owner at this point. I would have to also get permission from the buyers because they have equitable rights to the home. Okay, so equitable title is just a version of a title where you're upon completion of the contract. There it is. It's the right to own upon completion of the contract, but the seller cannot make big changes anymore. Okay, and they have to get permission. And so this is something sellers have a hard time like wrapping their head around, because they're like, well, I'm still the owner. Yes, you are, but you have now signed a sales contract saying that you're going to sign, and there's no way for you to get out of this unless for some reason title work comes back saying that you owe too much money, or that there's some title defect and there's no way to fix it. That's the only way a seller can get out of a sales contract. Unless, of course, guys, we're building in additional contingencies. If we're not, the standard sales contract does not give the seller any opportunities to get out. All of the opportunities to get out lie with the buyer, because there's more risk to the buyer, because the buyer doesn't know this home at all, right? Less risk to the seller, right? So equitable title, again, it's essentially the buyer's rights when they're under contract. Now, bare legal title is something totally different. This is ownership without the right of use or possession. So again, I told you guys earlier that Virginia is a title theory state. In other words, we follow title theory law. Now, title theory law says that when we buy a property and we're financing it, we're going to use a deed of trust. And what is a deed of trust? A deed of trust is a financing instrument, but it's not the same as a mortgage. Now, here in Virginia, we all call it a mortgage because, I mean, that's what the rest of the world, everybody knows the term mortgage, but people don't know the term deed of trust. It's not like a well-known word, right? A well-known document. So when we just call it a mortgage, but technically it's not. In Virginia, it is a deed of trust. And that deed of trust is different than a mortgage in the fact that a mortgage has the mortgage company and the borrower. Whereas in a deed of trust, it is the mortgage company, the borrower, and a trustee. And so in the state of Virginia, there's always a trustee that has bare legal title on your property until you pay that deed of trust off. You pay off your so-called mortgage, right? And then their bare legal title goes away. Now, why do they have bare legal title? Because they have the absolute right to sell that property right out from underneath you should you breach the deed of trust financing agreements. Whatever they are, you can't breach them. And if you do, the trustee could come in and sell that property right out from underneath of you. So those are the three of those.